be Honorable Vessels from the Freedom Front Plus and Honorable James from Action SA. Am I seeing Honorable James here? Thank you so much. Yeah, I wanted to be certain that you are here and South Africans see that you are here. There are two more honorable members that I'm seeing, one from the EFF and one from the DA. We want to thank you for your presence, Doctor. You can just and Honorable Pambo, thank you so much. Thank you so much for your presence here. I think there is no more members that I would have not acknowledged. If there is you can just alert me and then I duly recognize your presence. Thank you so much. Then our legal team is led by Senior Counsel Advocate Norman Arendse. Thank you so much, Honorable Arendse. He is also our Chief Evidence Leader. And then the core evidence leaders are Lerato Zikalala and Maria Mohwaitz. Thank you so much. Proud to have you here, women of South Africa. Can you once again raise your hands? Thank you so much. We have Andile Tejana from Parliament Legal Services. And then there are two gentlemen doing secretarial duties sitting here with me. If you don't see them, they will come to join me. It's Bonani Ramano and Pilot Kwebu. And then our witness, the first witness that the committee has agreed on, has arrived here. We take this opportunity to welcome you, Lieutenant General Ntanta Mkwanazi, the Provincial Commissioner for the KwaZulu-Natal Province. Welcome here. Honorable members and everyone from Parliament, staff, from the media, we once again welcome you. It is time that we should start with the proceedings. I think I'm done with the introductions. I'm now going to request the Senior Counsel, Advocate Arendse, to come and make an opening statement.
Thank you, Honorable Chair. Can you hear me? Honorable Chair, honorable members, my colleagues, members of the parliamentary legal team, and everybody who has more than ably assisted us in getting to this point where we can now commence these proceedings. Also, thank you to Lieutenant General Mkwanazi and all the other witnesses that we have interviewed and taken statements from for their voluntary cooperation and willingness to meet at our request, which has facilitated us to get to a point of readiness today. If I may make an opening statement on behalf of the evidence leaders, Honorable Chair. It is often said that success should be the natural reward for hard work, initiative, and moral uprightness. The opposite can also be true, and such is the urgency of the challenge we face. We need a collective sense of mission to change mindsets and to steer the nation away from a dangerous course. Just as we extricated South Africa from the mire of conflict, we are now called upon to use new tools at our disposal to build a prosperous, truly just, and morally upright nation. Democracy has taken root in our country and in our region, and we have peace and political stability. But all this will be little more than the shifting sands of illusion if we do not take decisive measures to strengthen the moral fiber of our nation. In this context, it is legitimate for us to examine the root causes of crime and corruption, the poverty that stares us in the face, the illegitimacy of the previous order which elevated lawlessness into an honorable deed, the sanctions era which made underhand dealings a glorified national pastime, and the low pay and repressive focus in the security and other public services which turned upon their head the moral standards that these institutions are supposed to uphold. It is legitimate to argue that it will take much time and effort to change all this, that to heal the wound of moral decay will need patience and forbearance. Yet, this should not result in our being incapacitated. It should not postpone the concrete steps against crime and corruption which we need to take. Now, Honorable Chair and Honorable Members, you might think, wow, Arendse SC has penned these really poignant and entirely appropriate words. But I'm quoting to you from an opening address which was made by our founding President Mandela at the Business Initiative Against Corruption and Crime Conference just over 30 years ago, on the 19th of August, 1995. Honorable Chair and honorable members of this committee, since our past President's speech in 1995, we have failed to heal the wounds he refers to, and our fight against corruption has floundered. Various attempts have been made to address the scourge of corruption, and most notably the Commission of Inquiry into State Capture, the so-called Zondo Commission, which was established by the President to address what was described as state capture. The Commission's detailed reports records the mechanism used to capture the state. Placement of politically connected individuals were used to control and manipulate public procurement, financial and contracting processes in SOEs and the public sector for private gain. This strategy was bolstered by the appointment of individuals in positions of power in law enforcement and tax administration. We also had the Nugent Commission to ensure that perpetrators were protected. This breach Section 195 of the Constitution, which requires public administration that is ethical, professional, effective, impartial, and developmental. Lack of compliance, transparency, and accountability in appointments of board members and senior executive enabled state capture. Honorable members, today we again convene at a critical juncture in our democracy as we consider the serious allegations placed before this honorable committee, which strikes at the heart of our democracy. On the 6th of July this year, 2025, Lieutenant General Nhlanhla Mkwanazi, the Provincial Commissioner of Police in KwaZulu-Natal, publicly revealed the potential existence and operation of a sophisticated crime syndicate that has allegedly infiltrated law enforcement and intelligence structures within the Republic. These allegations demand a thorough and unflinching examination. Indeed, General Mkwanazi has alleged political interference in the attempted disestablishment of the political killing task team, suggesting or alleging that there was a deliberate undermining of efforts to combat serious crime, in particular corruption. He alleged a potentially corrupt relationship between certain individuals and the Minister of Police, alleging collusion with organized drug cartels, and that these cartels exert undue influence over politicians and law enforcement officials within the South African Police Service, Metro Police, Correctional Services, the National Prosecuting Authority, the judiciary, and even members of the business community. The National Assembly, quite rightly, recognized these allegations of systemic corruption that has led to an erosion of public trust, and accordingly, it established this ad hoc committee in terms of Rule 253 of the Rules of the National Assembly to investigate these allegations fully and to report back to the National Assembly with recommendations to strengthen our institutions to prevent further abuse. Whilst the President has also taken these allegations seriously and appointed what is now known as the Madlanga Commission, this ad hoc committee focus addresses specific areas defined by its terms of reference, namely to investigate potential political interference, interrogating potentially corrupt relationships involving Minister Mkhunu, Brown Mogotsi, and Vusimuzi Kat Matlala, examining possible procurement irregularities within SAPS, and in particular, the 360 million rand SAPS healthcare contract with Medicare 24 Tswane, their role therein of Kat Matlala, assessing prosecutorial conduct, focusing on the investigating Directorate Against Corruption, IDAC, and whether its officials unlawfully interfered with police investigations or exceeded their mandate, probing the alleged existence of an organized crime syndicate controlled by drug cartels and its alleged infiltration of key criminal justice system role players, looking at the conduct of members of parliament with regard to classified information and potential links to criminal syndicates. Our inquiry must also consider whether Parliament's own oversight mechanisms have been effective in addressing these issues. Not only is this committee required to analyze and diagnose the problems and the causes of those problems, and whether indeed they are systemic, but also to propose forward-looking measures to strengthen the interagency coordination within the criminal justice system. This committee has a constitutional duty enshrined in the Constitution to represent the people and to ensure government by the people. It must exercise its power to scrutinize and oversee executive action with diligence and impartiality. Its proceedings must conform to the fundamental principles of the rule of law, legality, rationality, procedural fairness, and justice required by its terms of reference. Ultimately, this committee's task is not merely to conduct an investigation. It must safeguard the integrity of our institutions, to restore public confidence and trust, and to uphold the principles of justice and the rule of law, which is foundational to our Constitution. To that end, we will be guided by the evidence of the so-called, or we call them the SAPS, South African Police Service witnesses, in particular General Mkwanazi, and General Masemola, the National Commissioner, the ministerial witnesses, Minister Mkhunu, former Minister Pele, and current Acting Minister Kachalia, and other witnesses. We remain committed to transparency, unwavering in our pursuit of the truth. We will call General Mkwanazi and National Commissioner Masemola on the one hand, and Minister Mkhunu and General Sabia on the other. We will also call from former Minister Pele, Acting Minister Kachalia, as well as Deputy Ministers Matali and Boshiela. These witnesses will be called during the first phase of this hearing. The committee will decide and identify witnesses to be called in the second phase of these hearings. In regard to the evidence given by the witnesses, we draw attention to Section 16 of the Powers and Privileges Act, which requires witnesses called before the committee to answer fully and satisfactorily to all questions lawfully put to them, to produce any document they are required to produce, notwithstanding that the answer to any question or the document could incriminate them or expose them to criminal or civil proceedings or damages. Witnesses are, however, protected in that the evidence given under oath or affirmation before this committee may not be used against any witness in any court or place outside Parliament, except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in these proceedings. Thank you very much, Honourable Chair, Honourable Members. That's our opening statement. Could I now call General Mkwanazi as our first witness and ask the Honourable Chair to administer the oath?
Chair.
Honorable Malema.
Thank you very much, Chairperson. And good morning, colleagues and General. I don't understand on which basis do you want General Mkwanazi to take an oath? Because before us, we have no statement of General Mkwanazi. We have a supplementary statement. Supplementing what? Because he must first depose to us a statement, and if there is anything to be supplemented, it should be done so. The statement we have is a statement disposed to the Commission. We have said to this legal team here, time and again, that we are not a junior committee of the Commission. There is no statement of General Mkwanazi before us. There is a statement of General Mkwanazi to the Commission. And therefore, in the absence of his statement to the ad hoc committee of Parliament, on which basis do you want him to take an oath? You should know, Chair, that a supplementary statement should be supplementing the original affidavit, if you wish to say so. There is no such. And therefore, General Mkwanazi is not proper before us. And this legal team has failed us because in the deliberation, we made it very clear, if colleagues are honest with each other, we repeatedly said, we cannot use the statement of the Commission. We are not a junior of the Commission. We have nothing to do with what the Commission is doing. We are a Parliament, a Committee of Parliament. Now you want to use a material that is being used and sourced by a commission established by the executive in this separate arm of the state. It is wrong, it is unconstitutional. We have to do things properly. And the proper way is, there must be an original statement to us as an ad hoc committee. And if they so wish to be a supplementary statement, let it be. I even said, it doesn't matter, Chair, in that meeting. I said, we can even say to General Mkwanazi, the first pages of that commission statement, where the statement is directed to a commission, they can be amended to say the ad hoc committee of Parliament. And we have something that is directed to us, which will become our property, which will go into the archives of Parliament as General Mkwanazi's statement to Parliament. In the history of this Parliament, when our children and grandchildren and children of children are going to be looking for General Mkwanazi's statement to Parliament, they won't find it in the archives. So it's not proper before us. And the legal team is to be blamed, not himself. Thanks.
Advocate Arendse, can you please clarify that aspect?
Thank you, Honourable Chair, and in response to Honourable Malema. There is, with respect, a statement before this committee. The statement has now been sworn by General Mkwanazi. we call it a supplementary statement because much of the factual background was covered extensively by the evidence leaders in the Madlanga Commission of Inquiry, and that is the 3 volumes you have before you, or 3.1 and 3.2, which contains General Mkwanazi's statement and the annexes to that statement. At the Madlanga Commission, General Mkwanazi gave evidence under oath, although his statement was not declared under oath. Judge Madlanga administered the oath, and he gave his evidence under oath. And it would therefore be quite surprising that his evidence before us today would differ materially from the evidence that he has already given before the Madlanga Commission. I acknowledge what Honorable Malema is saying about us not playing second fiddle to the Commission, as it were. But the fact of the matter is this. After Parliament decided to appoint this ad hoc committee and the appointment of ourselves was finalized, the Madlanga Commission had also been proclaimed by the President, and their evidence leaders got hold of Mkwanazi first, and they started to take a statement from him, which they did, I think, General Mkwanazi, over a period of some 2 weeks. You will recall, Honorable Chair, that I engaged with the evidence leaders for the Madlanga Commission. You engaged with the chairperson, Justice Madlanga, in relation to when General Mkwanazi could become available to us. Given your terms of reference, you will recall this committee insisted that this hearing can only commence by us calling General Mkwanazi first. So for a period of some 3 weeks or more, we were constrained or prevented from engaging with General Mkwanazi to take a statement from him because he was unavailable. He explained his unavailability to you, Honorable Chair, and to the committee, and asked to be excused. As soon as he concluded his evidence before the Madlanga Commission, he indicated to us that he was now available to be consulted, and which we've done. Our consultation covers the evidence and the statement that he gave at the Madlanga Commission. We've attempted in this supplementary statement to avoid repetition. Much of what General Mkwanazi has been heard by honorable members of this committee, by members of the public and the media. In fact, his statement was his redacted statement was also made available to the media. So that is the approach that we've adopted, Honorable Chair, to this inquiry. What honorable members, Honorable Chair, what you will find different to what was done in the Madlanga Commission is that there'll be a lot more engagement with General Mkwanazi in relation to the issues that forms part of the terms of reference of this committee, and not necessarily before the Madlanga Commission. So General Mkwanazi has been alerted to that, and we've consulted him about it. and different versions will be put to him as opposed to what was the case at the Madlanga Commission. So it is not only appropriate but necessary that we've incorporated the Madlanga statement as part of his statement before this committee, so that the record will indeed in years to come show that incorporated as part of General Mkwanazi's statement to this committee is also the statement that he made to the Madlanga Commission. Thank you, Chair.
No, before I take the hands, I think what the honorable member wants to know is whether the sole statement that General Mkwanazi made at the Madlanga Commission, does it enjoy precedence over this? Because the understanding is that it is supposed to be an annexure to the statement that he has made with yourselves.
No, Honorable Chair. This statement enjoys precedence, but it incorporates by reference the Madlanga Commission inquiry, and there are aspects in this statement where we will cross-reference what he said in the Madlanga.
Yeah, I hear what you are saying. What he's trying to say is that we have two institutions of government, Parliament and the executive. And then Parliament has appointed an ad hoc committee. We have more or less a common list of witnesses. So when a witness comes here, a witness deposits a sworn statement to us in accordance with our terms of reference. And then when we come to the proceedings, we then say, this witness who is appearing before us has also appeared elsewhere. Your statement as the ad hoc committee is this one, but for ease of understanding, there is this other statement which you would have deposited elsewhere. For the interest of members, you can also read it. It's not compulsory. But if you want to enrich your understanding, you can also read this other statement. That is what the honorable member wants to know. And his problem is that the word supplementary is used when this statement is supposed to be an original statement before Parliament, because it is not a document of another arm of government. It's a document of this arm of government, which is Parliament. So what we then have to understand between yourself and General Mkwanazi is the ownership of this document. That this is the document which I myself as General Mkwanazi had deposited before you as Parliament. And for the purpose of these proceedings, I can confirm that yes, this is the statement I made with yourselves. If there is any other statement made elsewhere, you can also go through it, it's available. But for the purpose of these proceedings, I confirm that the document before you is the document that I deposited with yourselves. Can we have that understanding?
Well, there's no better person to answer that, Honorable Chair, than General Mkwanazi himself. He can, hence I asked you to administer the oath. I will ask him whether this is an original statement that is made to this body.
Yes, let me take the hands. Before I take you, Oscar, let me go back to Honorable Malema, because he's the one who raised this point. He may want to make follow-ups, and then the list will be in this order. It will be Honorable Malema, it will be Honorable Skosana, Honorable Nombalo, Honorable Nwala, and then Honorable Mwango.
Not thanks, Chair. I think the evidence leader, and this is so unfair on General Mkwanazi. If we had a way, we should have just asked him to step out so that we can debate this. The senior counsel can't say that. Can't say the first statement to us is supplementary statement. That coming from a senior counsel. That the first statement you make is called supplementary statement. What law are you teaching people? It's unacceptable, and we can't help them, Chair, to cure it here in front of cameras. He has to go back and do the right thing. Because even if General Mkwanazi says, this is my statement to Parliament, but what is written on this thing is supplementary statement. You can't change it. It's here before us. You are going to call General Mkwanazi before this committee without an original statement. Where have you ever had a situation where you are told the first statement to be disposed is supplementary statement? If we're to ask the senior counsel, where's the original statement? He won't produce it. So if this is the original statement, let it be, let them go and correct it. So it serves here properly. And then we all proceed. And what makes it painful is that it doesn't matter whether colleagues want to do whatever they want to do. We debated this matter many times in this committee and emphasized that General Mkwanazi will have to dispose a statement to the committee, even if it means cut and paste, as long as there is an original statement to the committee. So that answer doesn't even, General Mkwanazi doesn't get involved anywhere. He was called, he was asked questions, he was being helped by evidence leaders on how these things can be done. So to invite him now and say, is this an original statement or not? It's incorrect. He gave them what they asked him to give them. If they were not satisfied, they were supposed to come back to us. Now, the legal team does exactly what we want when we appointed the legal team. That there's no legal team which is going to take decisions on behalf of this committee. Now he goes and takes a decision that a supplementary statement will be an original statement and brings it here and embarrass us in front of cameras like we are a group of people who don't know anything. He says, General Mkwanazi took an oath at Madlanga Commission. And therefore, because he took an oath at Madlanga Commission, because we do what Madlanga has done, why should he take an oath here? If that's how it works. He disposed the statement at Madlanga. This statement at Madlanga is the statement before us. We must accept that. We must also accept Madlanga's oath. Going to take an oath twice on the same statement. On the same statement. There's no law that says that. I might not be a lawyer, but I'm a lawmaker.
Honorable Skosana.
Yeah. Thank you, Chair. I'm not sure, Chair, whether when we sat on our meetings, in fact, before even this ad hoc committee was set, because we sit in this portfolio committees.
Chair, honorable members,
and it's really embarrassing, I must say,
colleagues,
that after we agreed that we are not the subcommittee of the Madlanga Commission.
and everybody who has
And now we are
more than
told that
ably
there's a
assisted us
supplementary
in getting to this point where we can now commence these proceedings. Also,
thank you, Chair.
to
Not because you are talking to
Lieutenant
someone
General
there.
Mkwanazi,
That
all the other
we have to have a cut
that we have
and paste
interviewed
is not acceptable
and
as well.
consultants from for their
I mean, we were told that there was a
volunteer
consultation with
willingness to meet,
the Provincial Commissioner
and
General
others.
Mkwanazi.
which has facilitated.
We are going to be
us
having a
to
different
the
view,
point of
you know,
this.
here at the ad hoc
Today.
committee,
Um,
not what we are told today by the senior
If I
counsel.
may make an
And I think that
statement
I will
on
support
behalf of the
my
evidence
colleague
leaders,
on that. Perhaps it
Honorable
would be
Chair.
proper that General Mkwanazi is
It is often said
excused.
that success
Us as committee
should
members
be
discuss this
the
matter
natural
because
reward
really
for hard work.
we are letting the
initiative,
country again
and
down.
moral
It's
uprightness.
like we don't know what we are doing.
The opposite
We know where we come from in this country. You know,
And such is the
we had a
urgency
case where somebody was
challenge
sentenced
we face.
without trial.
We need
before
a
standing before the
collective
judge.
sense of mission,
Today we are finding
change
ourselves in
mindsets,
this
and to
again,
steer the nation
where we are told that
away from a
the
dangerous
statement was done, the
course.
oath was taken in the Madlanga Commission.
Just
It's
as we
unacceptable.
extricated South Africa
And I think we should
from
not
the mire
go
of
that route.
conflict,
My
we are now
appeal to
called
you,
upon
Chair,
to use
and to
new
members
tools
is that
at our
perhaps
disposal
can we
to
take
build a
an
prosperous,
adjournment
truly
on
just
this
and
matter?
morally upright
I think it will be proper.
nation.
Otherwise, we'll be continuing doing the wrong
Democracy has
thing.
taken root in our
We are
country
not a
and in our
subcommittee of
region.
Madlanga Commission. Whatever happened at
we
Madlanga
have-
Commission happened at
and we
that
have peace and political
commission,
stability.
not here. I thank you, Chair.
But all this will be little more than the
Honorable Nombala.
shifting sands
Yeah,
of illusion.
no, thank you very much,
if
Chair.
we do
Chair,
not
let me
take
start by
decisive
sharing my
measures
deepest
to strengthen the
discontent as
moral
well.
fiber of our
That we are
nation.
starting on a very bad note.
In this
From the word
context,
go,
it is legitimate
we're
for
messing
us to
things
examine
up.
the root
And I think we
causes
shouldn't
of crime
allow
and
that
corruption,
if we want to enjoy the
poverty
respect
that
of
stares
South
us in the
Africans.
face,
Chair,
the
we
illegitimacy
deliberated
of the
on this,
previous
and
order
I
which
remember
elevated
we did not only
lawlessness
deliberate
into
on
an
this
order of
during our
need,
ad hoc committee
the
meeting,
sanctions era
even
which made
during a
unland
joint
dealings
committee meeting
glorified
between
national
the
pastime,
Portfolio
and the
Committee
low
on
pay and
Justice and the
repressive
Portfolio
focus
Committee on
in the
Police,
security
which
and other
gave
public
birth to this
services,
committee.
which
We
turned
debated
upon
the
their head
role
the
that
moral
should be
standards
played by
that
Parliament.
these institutions
And we
are
said
supposed to uphold.
the doctrine of separation of powers is very
legitimate to
clear
argue that
on
it
the
will
role
take
that should be
much time
played
and effort
in
to
terms
change
of the
all this,
constitutional mandate by each
that to
state
heal the wound
or
of
by each
moral
organ of
decay
the state.
will need patience
But
and
today,
forbearance.
we find ourselves in a situation
This
where
should not
we are
result
being
in our
misled
being incapacitated.
by the technical team
should
or
not
by the
postpone
legal
the
advisors of this ad hoc committee. Because if you say we must rely on the statement of the Madlanga Commission, you are simply subverting the constitutional responsibility of Parliament in this regard. And let's avoid this thing of mentioning Madlanga. Madlanga is a decision of the executive, not a decision of Parliament. We are doing our own, we are initiating our own process here. So we're not going to do any copy and paste kind of work and said, no, because this one has been done by Madlanga. Because if we are doing that, in future, we are going to be told that we can't investigate some of the issues here in the terms of reference because they were investigated by the Madlanga Commission. So, Chairperson, our view is very simple on this one. This must be amended. We are not going to accept this document as it is termed as a supplementary document. It must be an original statement by Lieutenant and General Mkwanazi, because even the terms of reference, they are not similar. They are slightly different. So we can't be subjected to a process, some of us that do not even have a confidence in. Because some of us don't have confidence in the Commission of Inquiry. We don't have confidence. Now you want to take the work of that commission and impose it here. We're not going to allow that. Thank you very much.
Thank you very much, Chair. Thank you very much, Chair. Chair, you will recall that the Senior Council did confirm to us in the last ad hoc committee meeting that there will be an original statement for the work of the ad hoc committee, and the Commission of Inquiry statement will be just an attachment. So when I saw that the statement itself is addressed to the chair of the ad hoc committee, I thought that's what we have agreed about. So when I saw supplementary, I thought that the general is supplementing the statement of the 6th of July. So hence, I didn't notice what Honorable Malema has noticed. I think, Chair, it's just unfortunate, and we must plead with our evidence leaders to avoid making such mistakes so that we don't tamper with the credibility of the process itself. So in trying to mitigate the situation, maybe, Chair, because it's supposed to be sworn statement instead of supplementary statement. So I would want to request that we adjourn for 15 minutes and that defect be cured. Then we take the general to be administered in terms of oath. Then we proceed, Chair. Thank you very much.
Honorable Mwango.
Thank you, Honorable Chairperson. Good morning, colleagues, and Honorable General Mkwanazi, you are not Honorable Member yet. Yes, I would like Honorable Chairperson to support the proposal that we adjourn this meeting for 15 minutes or so and correct these distortions that are in here, because the letter written to you, Honorable Chairperson, which is attached, which is part of volume 1, actually reads, please see under cover hereof the witness statement of Lieutenant General Mkwanazi. It doesn't talk about a supplementary. But on the following page, the following page actually starts off by saying supplementary witness statement of General Mkwanazi. So clearly there is a distortion here. So I think this needs to be corrected, but it cannot be corrected in front of the, the cameras, but we need to adjourn and then get these things corrected so that we can resume our job.
Okay. Let's do like this so that I have listened to what you have said, and you are very right. The two institutions are separate. Every document that comes here before Parliament must be an original document before the eyes of Parliament. But maybe what we must do is that before we adjourn to correct the typo, I'm going to ask respectfully General Mkwanazi to confirm that the statement that has been made, I know that procedure.
On a point of order, Chair. On a point of order.
Yeah, can I finish what I'm saying? So
on a point of order, Chair.
when you call the point of
No,
order,
I insist on a point of order. We are about to mess up. On a point of order.
okay, point of order taken.
There is no General Mkwanazi before this committee. He's not here until we've satisfied his appearance before us. It is procedurally wrong. Because once you talk to him, the first thing he must do, the first step he must do is to take an oath. Is to take an oath. Then, only then, he's before us. In the absence of the oath, let's release him. He's not part of this mess. He's a witness called to come before us after he was told he met all the requirements. You can't ask him anything. The only time we are going to interact with him, because if you ask him something, I'm also bound to ask him something, because me and you enjoy the same rights. And then the whole house is going to start asking him questions. He has not administered an oath of, it's not taken an oath. So please, Chair, we are all agreed. Let's release him. And I don't know if 15 minutes is realistic, because he's going to take up issues with the legal team as well when they arrive there. So I don't know, but to engage General Mkwanazi is actually out of order, because he's not before us. He has to first he's not a member of Parliament. He has to first take an oath, and then from there we can engage him.
Yeah, no, that is a valid point, Honorable Member, and I 100% agree with you that he is not properly appearing before us. And before we ask him any question, he must have taken an oath with us. And I will stand by your advice, because I wanted to save, and I understand that procedurally I would have been wrong, so that we must know whether we are going to proceed or we are not going to proceed. Because for us to proceed is only if we can know whether what is contained in this document that is before us is what he's going to agree with. That yes, this is what I deposited before you, and then the corrections which are made must be made, and then we reconvene and proceed. But for now, I agree with Honorable Malema that we will not be able to ask him any question until he has taken a statement with us. So we are going to break now. We are going to break senior council and determine whether the mistakes that are on the document are correctable. Yes. Let me take senior council, Honorable Mkwanazi.
If I may just remind the honorable members of the events leading up to this hearing. After the National Assembly appointed this committee, the Madlanga Commission had also been established. Central to this committee's terms of reference were the allegations made by General Mkwanazi. When we at some point suggested or proposed that perhaps we should make a start with some other witness, so that at least we can get the hearings going, the committee, I think, near unanimously said, no, we must first call General Mkwanazi. But General Mkwanazi became unavailable and wrote to you in that regard. And Judge Madlanga had also spoken to you and the evidence leaders to me to say, unfortunately, General Mkwanazi is engaged initially in statement taking and subsequently that he would be appearing before them for 4 or 5 days. And that made General Mkwanazi unavailable. You, Chair, in an exchange of letters with Judge Madlanga, agreed that we will, by way of cooperation and mutual respect, work together and try and save some time and unnecessary costs by exchanging documents and witness statements, etc., without either of the two parties, because of the separation of powers, being bound by what the other had either drafted by way of the documents or any evidence that was given. To the extent that it has been said or it's inferred that this committee and we are bound by the Madlanga statement or the evidence that General Mkwanazi gave before that commission is not correct. It's not legally correct. We are not bound by it. But to the extent, and that is what General Mkwanazi says at paragraph 8 in his sworn statement, which has now been sworn and which is an original statement. He says that I consulted with the committee's evidence leaders on 25 and 26 September. Having reviewed the terms of reference, I observed significant overlap in the background factual issues and evidence are provided.
Let me stop you there. Let me stop you there.
So just I can just conclude, Chair.
Just hold it there, City Account. You see the problem. The problem may not be the contents of the statement. The problem is that this document, when it appears before the committee, it must be an original document that the committee can have or can claim ownership. And that is why members have a problem with the use of the word supplementary on the document. It must be original statement made to the ad hoc committee by General Mkwanazi. if you go to the contents, you are trying to justify a document that self-justifies itself. So we want you to correct that mistake of using the word supplementary on the document. Let it become an original document to the attention of the ad hoc committee of parliament.
The Chair, may I request that we simply be directed or instructed to remove the word supplementary? I think that is the unfortunate word that has been used. This is, and General Mkwanazi can confirm it under oath, this is very much an original statement that we've taken.
Senior Counsel, I hear what you are saying. The members are saying that he can only confirm those documents once oath has been administered. So if there is a weight that suggests that this document has been brought from elsewhere and is not our document, this meeting will not proceed. So if you were to write original on the document and then you bring it here, there is nobody who will have a problem with it. It is only the witness himself or herself who can have a problem to say, why do you say this paragraph is original? Because it's not what I deposed with yourselves. So the members are requesting that, or are instructing that the document cannot be supplementary. Parliament has original powers. And for sure, you also know that in this country, we practice what we call parliamentary executive system. The executive itself is a creature of parliament. Without parliament, you don't have the executive in the South African parliamentary system. So can we please adjourn without deliberating further on these matters and get to a point where the witness is called to own the statement or not, please?
Chair, may I just say lastly that
No, Senior Counsel, I'm not, you know, if I'm not allowing members to speak, I can't allow you to speak any further. We adjourn and then we correct.
Check, I want to raise on a different point.
Yeah, it's a separate. Yeah, no, it's fine. You will raise that point when we were a committee. Yeah.
Because I don't think what the senior counsel is doing to you is acceptable. We can't allow that.
Yeah, what I'm
Can't allow
saying,
being undermined like that.
what I'm saying, honorable members, is that
I really have no confidence in him from what he did now. We must change him.
I have
To argue with us and argue with you in front of cameras, and you allow that.
I have restrained the senior counsel, honorable member. So what we should do is to adjourn. The instructions are very clear. Let's correct the statement. We must look, our business is to allow the witness to make a presentation before us. And senior counsel, please help us to have, the witness is here. Please help us to have the witness making the presentations, which not me and you, but which South Africans want to hear. Please, let's do this for the people of this country. And I have said we have agenda for that correction to happen. Thank you so much.
Chair,
Yeah.
the statement has not been signed. The statement before us, there's no signature.
Yeah, that is technical.
No.
No, it's technical.
No, but it can be.
We have agenda.
Chair, for how long are we adjourning? Chair. Chairperson, he's not, for how long are we adjourning? For how long?
T, 1, T. Ephraim, can you hear me?